So we have Astha, Abhigyan, Aditya, Ankit, Anshul, Arpan, Ashutosh, Ayush Bothra, Ishpreet Singh, Janveer Singh, Jamima, Naman Jalan, Naveen Chandlani, Neha Singh Rathore, Priyam Milan, Priyanshi, Raghav Dubey, Sambhav Garg, Sanya, Sarvan Sinha, Saurabh Yadav, Shara Khan, Shreya Dharan, Shubham Singh, Tarush Khandelwal, uh, Vanshika, Vatsal, Yash Chaudhary, and Yashvardhan Tiwari in the class now. So let us just start the class. I think somebody has any conversation, or hi Ankit. Okay, so let us just go with the presentation. So yesterday, by yesterday, we have studied about the directors, independent directors, and the thing, and those people who are managing the company. Today we will study about that, to what extent these people, those who are directors or of the company, or those who are the members at the top level, how can they actually manage the company, or what are the reasons, or what are the things which is called as a mismanagement of the company. They may, out of the power which they have, they may oppress the people, those who are minorities. So the Companies Act comprise of certain provisions which is good enough to address the operation and mismanagement by the powers of such directors. So let us study about the operation and mismanagement in the company in today's class. So what is operation and mismanagement? So the dictionary meaning of operation is something unjust, or something a cruel behavior, or something a cruel exercise, or you have imposition of certain things, or you are making someone do the things without his will. Okay, so that is called operation. So you are actually operation itself is comprised of pressing, or you are actually, what you are doing is you are compelling some other people, or you are imposing your decision on some other people, those who are unwilling to accept it. Okay, so the conduct complained of should be at least involve a visible departure from the standards of their dealing, and violation of conditions of a fair play on which every shareholder who entrusted his money into the company is entitled to rely. Okay, so this is a very comprehensive definition given. The complaining member must show that he is suffering from operation and his capacity as a member, and not in any other capacity. So this was given by Lord Cooper in the case Elder versus Elder and Watson Limited. So there was a company in which this definition has evolved, and Lord Cooper has given this definition as a verdict to in this case. So so what operation is, that it is the conduct which is complained, it should involve a deviation from the standards, that what should have happened and what has actually happened. There has to be a deviation, or there has to be some material violations of the conditions which is against the fair play, and which is against the shareholder. And as a shareholder, everyone has given their money to the company. It is not that a person has given the money to the company just in order to be victimized out of the democracy of the company. So it should not be like that, because in democracy, what happens, those people who are are in power, or are in more in number, they actually, or better I say, those who are in majority should not oppress the minority as such. Okay, and what is mismanagement? Mismanagement is when the affairs of the company are being conducted in a manner which is prejudicial to the public interest or company's interest. Now here there is a difference between operation and mismanagement. Operation is something personal, whereas mismanagement is something related to public. On mismanagement also happens when by reason of material change in the management and control of a company, the affairs of the company are likely to be conducted. So mismanagement is present also and futuristic also. So if certain things are happening in the company which is prejudicial to the interest of the company or prejudicial to the interest of the shareholders, as such, then it will be called as a mismanagement. We will be studying this in detail. So what is given under the Companies Act? So management of a company is based on a majority rule, but at the same time, the interest of minority can't be completely overlooked. So company actually works on the principle of majority. So while talking of majority and minority, we are not talking of numerical majority or numerical minority, but the majority or minority of voting strength. Okay, so the reason of this distinction is that a small group of shareholders may hold the majority of holding, whereas the majority of shareholders among them hold a very small percentage of the share capital. Now, when we talk of majority and minority, here you will appreciate, so each and every share is having one vote. So it may happen that very less number of people may hold a lot of shares in the company, and very large people may hold very small shares in the company. So if we see it from that point of view, then it can be, if you just come at the people's level, so very less people will be having a control on the company against a large number of people, those who are having less control. Okay, so the company management is actually like that. So that's why the reason of distinction in a small group of shareholders may hold the majority of shareholding, whereas the majority of shareholding among them hold a very small percentage of a share capital. So once they acquire the control, who? The majority. Once they acquire the control, for any practical purposes, do whatever they want with the company with practically no control or supervision, because even if they are questioned on their acts in the general meeting, they always come out winner because of the greater voting strength. So less people may have a higher voting strength, and more people may have a very less voting strength because the company management is like that. Okay, so company is managed in that way. So whosoever has invested more definitely will be having more chance to govern the company, and may impose certain things on the minority also. So the Modern Companies Act contains a large number of provisions for protection of the interest of the minorities in the company. So this is a very important case which is actually against the majority. Actually, what happened in this case I will discuss. So there's a rule of Foss versus Harbottle. So this rule was laid down in 19th century in the case of Foss versus Harbottle, and where the action was brought by two shareholders in a company against the directors, charging them with concerting and effecting various fraudulent and illegal transactions whereby the property of the company was misapplied and wasted, and praying, what was the pray? Praying that the defendant might be deceased to make good to the company the losses. So the action was rejected in respect of those transactions which a majority of the shareholders had the power to confirm. What was the brief opinion of the court? The brief opinion of the court was, if the thing complained of is a thing which is substance, the majority of the company are entitled to do so. Or if something has been done irregularly, which the majority of the company are entitled to do so regularly, or if something has been done illegally, which the majority of the company are entitled to do legally, there can be no use in having litigation about it. The ultimate end of which is only that a meeting has to be called, and then ultimately the majority gets its wishes. So what is there over here? In the case of Foss versus Harbottle, it was totally the majority of the company who actually wins. So what are the advantage of this rule? So the advantage of this rule of Foss versus Harbottle is that there is a recognition of a separate legal personality of the company. Okay, so there is a multiplicity of futile cases which will be avoided, and preservation of the right of a majority to decide is there. So anyhow, one or the other way, if you see, the decision in the Foss versus Harbottle is totally in favor of the majority. So if the decisions are in favor of the majority, what will happen? It will give a company a better power. Why? Because they will be considered as a separate legal entity, separate legal personality, and the company can take its decisions by itself. Next is your multiplicity of futile suits to avoid it. So if again, if the people majority is taken care of, then every now and then the people will be coming to the court for getting resolved certain things. So that is overcome. At the same time, the preservation of the right of a majority to decide is there, which is a foremost important right. Okay, because it is majority who has to decide what is to be done and not the minority. But on the contrary, on the other hand, there are certain exceptions to this rule of Foss versus Horvotel. So first thing is the Ultra Virus Act. So any act which the directors are doing with the majority, because directors are less in number and they have high number of shares. So if certain things they are doing with majority, and that is Ultra Virus Act. Ultra Virus means beyond the powers. So such an act can be put down even by the minority. Okay, because Ultra Virus Act is not allowed, because it will make the entire company liable for it, and it will give a question mark on one of the advantage of this, that is having a separate legal entity. Okay, so a person who are behind this will be, will be personally responsible, or the company will be held responsible for certain things, or you can say the Ultra Virus Act should be avoided because it is beyond the powers of the directors. Next is fraud on the minority. If the directors are doing certain things which is actually is a resultant of a fraud on the minority. For example, these the directors may be having 51% of the share capital of the company, which is a majority. And suppose this 50% of the share capital of the company is held by suppose 5 people or 10 people, and the rest of the 49% of the share capital is actually distributed to the public for subscription. And this public, nobody knows that somebody is having 2 shares, somebody is having 1 share, but collectively they become 49%, which is again a substantial part. So if this 51% are playing on a fraud in order to defraud this minority, and they have intention to take away the money, or they have intention to play with that money, then such fraud on the minority is not accepted. And this is again an exception of the rule of Foss versus Horvotel, that majority always prevails. Okay, so what is the rule of Foss versus Horvotel? Majority always prevails, and there are certain exceptions to it. Next is the act which is requiring a special majority. So there are certain acts which are listed in the companies itself. For example, change in the name of the company, right? If the company wants to go with some merger and acquisition, or there is a change in the object clause of the company in memorandum of association. So these all will be requiring a you can say it will require a special majority to make certain changes. So with regard to that special majority, if the changes are to be taken care of and the changes are to be done, the majority cannot play an important role over there. So there also the minority shareholders have to be considered in that case. So next is wrongdoers in control. If this means if there is something wrong which is being done at the top level management, by having this exception or accepting this exception of a Foss versus Horvotel, these wrongdoers will be in control. Next is the individual member rights. If there is any infringement of individual member rights, rights of the individual member, for example, right to receive dividend, right to be informed about the general meeting of the company, right to participate in the voting of the company. So these all are the individual membership rights which each and every member has. Or for example, the right to transfer the shares to some other person. Okay, if the company is widely held public limited company. So these all are the rights which individual members are having. So in order to just ensure that individual member rights are also protected, the rule of Foss versus Horvotel can be an exception, that the majority always prevails. So here even one shareholder is having some rights which are infringed, then it is unconstitutional, and he can file a suit against the company and its director for exercising his individual membership rights. Next is your operation and mismanagement. So that's what we are dealing with. Okay, so if there is some operation and there is some mismanagement happening in the company, so that operation and mismanagement will also be taken care of, and the government can take a direct action in the case of operation and mismanagement, and can get the company or the shareholder rid of that operation investment, or provide them the relief accordingly. Next is the rule of application of FOSS versus orbital in Indian context. Okay, so in Indian context, how it is being taken care of. So in Delhi High Court versus it is the case of Delhi High Court in ICICI versus Parsuram Puria Synthetics Limited. Okay, so this was a case in 1998, was held that an automatic application of FOSS versus orbital to Indian corporate realities would be improper. Here, the Indian corporate sector does not involve a large number of small individual investors, but predominantly financial institution funding at least 80% of the finance. In these financial institutions which provide entire funds, almost the entire funds, okay, for the continuous existence and the corporate activities, though they hold only a small percentage of shares, if these financial institutions which have really provided the finance to the company's existence, and therefore to exclude them or render them voiceless on an application of the principles of FOSS versus orbital will be unfair and unjust. So what is the contention over here is that if the major investment, if it is taken from any of the you can say from any of the for any of the financial institutions, in that case what will happen? In that case there will be, means those people will also be included in any of the decision making as such. Okay, then only it will be justifiable. Otherwise, those people, those who are providing the actual capital, though they are not a part of the system of taking decision, so their money should also not be at the stake, though they are not shareholders, but they are only the investors. That's why the concept of the nominee director has come. So such persons can actually appoint a nominee director also on the board of the companies. Next is your ultra vires act. So where the director representing the majority of the shareholders perform any illegal transaction or any ultra vires act of the company, an individual shareholder, even a single shareholder, please note it, that is having a right to bring an action. So the majority of shareholders have no right to confirm an illegal or ultra vires transaction of the company. In such a case, shareholder has a right to restrain the company by an order of injunction by the court. So court can provide an order of injunction, means an order of stay, that whatever is being done over here is something ultra vires act. So a stay can be brought out by even a single member, okay, against the company. So this is there are two cases over here. So if you see in Bharat Insurance Company versus Kanhaiya Lal, this is a case of 1935. The plaintiff was a shareholder of Bharat Insurance Company. One of the object of the company was to advance money at interest on security of land, houses, machinery, and other property situated in India. Now, what happened? The plaintiff complained that the several investments has been made by the company without adequate security and contrary to the provisions of the memorandum, and therefore prayed for the perpetual injunction to restrain it from the making such investment. So what the court observed? The court observed in all the matters of internal management, company itself is the best judge for the affairs and the court should not interfere. But application of assets of the company is not a matter of internal management. As the directors are acting ultra vires in the application of the funds of the company, a single member can file a suit. It means that the rule of FOSS versus orbital will be inoperative over here. It will not be operative. Okay, and majority shareholders can always cannot have a power over the minority over here. So now the majority shareholders have taken a a decision to give the loan on inadequate assets. It means the entire company is at the risk, because if the person will not pay, this property may not be sufficient to recover the amount. So in that case, there will be a problem for the minority and majority, all the shareholders, and even for the existence of the company. So in that case, anyone can file a suit. Okay. Next is fraud on minority. So where an act has been done by the majority, and which is a fraud on the minority, in that case the action can be taken. So the majority of the majority of members of the company A were also the members of the company B. Okay, so this is regarding some holding and subsidiary. So at the meeting of company A, they passed a resolution to compromise an action against company B in a matter allied to be favorable to company B, but unfavorable to company A. Okay, held the minority shareholders of company A could bring an action to have a compromise set aside. So that can always be done because the if there is some fraud of certain and fraud means there is something befooling of the minority in favor of the majority. Though there is no clear definition of expression fraud on the minority asset, the act is not at all defining what do you mean by fraud on minority. But the court decides in a particular case according to the surrounding facts. The general test which is applied to decide whether the case falls in the category of fraud on the minority or not is whether the resolution of the majority is a bona fide for the benefit of the company as a whole or not. Okay, so this is what it is. Next is your wrongdoers are in control. If the wrongdoers are in control of the company, the minority shareholders representatives action for the fraud on the minority will be entertained by the court. So the reason for it is that if the minority shareholders are denied the action right of action, their grievances in such a case would never reach the court, for the wrongdoers themselves being in control will never allow the company to sue. So it is a simple point. Next is your this is one case of Glass versus Atkin. So what happened? A company was controlled equally by two defendants, okay, and the two plaintiffs. So four people were there and they were having equal control over the company. So plaintiff brought an action against the defendant, allying that they had fraudulently converted the assets of the company in their own private use. The court allowed the action and observed, while the general principle was for the company itself to bring an action where it had an interest, since the two defendants controlled the company in the sense that they would prevent the company from taking the actions. Okay, so again, what the thing is, the company here itself cannot take action. Okay, so those who are the wrongdoers, actually they are preventing the company to take action because the company works through its directors. So here the other two have actually brought the action even if there was no majority, but still the action happened as such. Next is the act which are requiring special majority. I have already talked about there are certain things which required a special majority. If the if in that case special majority is not there, special majority means you have to include some minority people. 75% of the total voting power has to be there in certain cases. So if it is not there, or if there is some insufficient notice, or the resolution has not been passed properly, or there is a meeting which has not been held, and these people want to, or the directors want to do something which is totally against the minority, then it can be checked for. Next is your individual membership rights. So individual membership rights are not invaded by the majority of the shareholders. He is entitled to all the rights. So each and every individual is having a right in the company itself. So for example, right to receive dividend, right to vote in a meeting. So by virtue of any decision, if any of the individual rights is getting affected, in that case, that particular even one person can file a suit against the company and its directors for bringing a stay or for just stopping them to do certain things which are against his individual membership rights. Next is the prevention of operation and mismanagement. So minority shareholders are empowered to bring in action with a view to prevent the majority from the operation and mismanagement. These are there are some statutory provisions regarding that. So this is, you can say, a statutory remedy. So a Companies Act and the decided cases suggests that a majority shall not be allowed to act in an unfair, fraudulent, or oppressive way against the interest of the minority. So in Companies Act 1956 also it was extended, and Companies Act 2013 also the same things are there. Okay, so it extends the protection to the minority by granting various rights to the minority. Okay, so it is that there are certain rights given, and it gives a clear cut, you can say, the process how it can be done. So the variation of the class rights, the rights attached to shares of any class can be varied under section 106 of the Act with the consent in writing of the holder not less than 3/4. Now again over here 3/4 majority or 75% majority is required to in order to pass a resolution, and that too in a separately in the meeting of the shareholders. Okay, so but the holders of not less than 10% of the shares and the class who has not assented for the variation may apply to the code. So, so minority should also be in majority. Okay, so even one person cannot file, but here at least 10% of the shares can file a suit against for the variation of the class rights. Okay, so next is a scheme of construction. I have already talked about construction, reconstruction, amalgamation, merger, operation and mismanagement, and alternative remedy to the for the winding. So finally, what is the remedy? If nothing could happen, then winding up of the company can happen. Okay, so when in the winding up the company, those people who are these minority shareholders, they will get their money back. Okay, but this is something which is very harmful because the company will lose its existence after the winding up of the company. So there are certain statutory remedies which also include the investigation of the investigation by the government. Okay, so that is also there. Okay, so where in case of a company on a report by the registrar under subsection 6 and 7 of section 234, read with subsection 6 of section 234, where in case of a company having a share capital or application either not less than 200 members of the company holding not less than 1/10 of the voting power thereof, and in case of a company not having a share capital on the application of not less than 1/5 in number of persons in that company, can file a complaint for the or can request the investigation of the company under section 234 and 235 of the Companies Act. So this is the power which are given, and what will the government will do? The government will appoint one or more competent persons as an inspector to investigate the affairs of the company, and a report can be given to the central government, and finally it can be decided whether there was a mismanagement or not, or investigation can be taken care of. Next is a prevention of operation. So the application to company law board, now it is called tribunal. So previously it was CLB, now it is NCLT. NCLT is National Company Law Tribunal. So the first remedy available to the oppressed minorities to move an application or move to the company law board. So whenever the affairs of the company are being conducted in a manner prejudicial to the public interest, or in a manner which is oppressive for any member of the members, an application can be made to the tribunal. So whom they will go? They will not go directly to the government. So there is a tribunal for this purpose. So to the tribunal they can be. Now who can apply? Any members of the company who complains that the affairs of the companies are being conducted in a manner oppressive to any member or members, including any one of themselves, may apply to the court for an order under this section, provided such members have a right to apply by virtue of section 399. So actually section 399 actually gives you the qualification of a person who can actually apply. So the section comes into force only when the aggrieved member is able to show that he suffered an injustice in the capacity as a shareholder and not in any other capacity. For example, a person who is an employee of a company and also a shareholder. So if being an employee of a company, some operation has happened or something he has been told to just do which is against his willing. So being an employee of the company, he cannot bring a suit against the company being a shareholder. Okay, so his capacity as a employee is different from a capacity as a shareholder. So his capacity as a shareholder will be considered over here, not as a employee. So a person having, because it will be seen whether the same things are applicable to other shareholders also or not. Okay, those who are not employees. So in that case, it will be seen in from this point of view. So if it is correct, then the things may proceed further. Otherwise, it will be rejected. So mismanagement. What is mismanagement? When the affairs of the company are being conducted in a manner prejudicial to the public interest or the company interest. Okay, or when by reason of material change. Now this thing is, now if you see the first point and second point, the difference is that in second point there is likely to be some operation may happen, and in first point the things have already happened or is happening. So the first point is regarding the past and the present, and the second point is regarding something which is futuristic, which may happen. So there is it is better to prevent. So that's why it is called prevention of operation and mismanagement. Okay, so when by reason of a material change in the management or control of a company, the affairs of the company are likely to be conducted in a manner prejudicial to the public interest or the interest of the company, then it is called mismanagement. So the acts which can amount to mismanagement. So because mismanagement can be, you can understand by just seeing this particular slide, that what can actually be a mismanagement by the directors. Okay, so where the company is of serious in fighting between the directors. So directors actually are not at all in line with each other. Okay, so there is infighting going on amongst the directors of the companies itself, and because these things are there, it is likely that the affairs of the company may be at the stake. Okay, second is where the board of directors is not legal and illegally is being continued. Okay, so a person, or there are a number of persons in the board which are not supposed to be there. Or for example, a person in the board is likely to be retire after 3 years, because retirement of directors must happen after 3 years. Or suppose there are no independent directors in the board, or a director who was to retire after 3 years is still continuing and it's the fourth year going on. So there is a illegal board constituted, and such illegal board, because it is illegal, it will also do all the things which are illegal. So if it is learned by some member that there is something illegal going on, or the board is also illegal, then he can actually bring the action. Next is where the bank accounts was or were operated via unauthorized persons. So the company's bank accounts are being operated by some person who are not authorized to operate it. For example, a person who was director of a company has retired by rotation, and he was actually supposed to sign the checks of the company as such when he was a director. Now still his name has not been changed, and he is still signing, and the bank has not been informed that the person has actually changed the thing. So in that case also, the person will not be, it is illegal for that person to operate the account of that particular company. And if some shareholder is having a knowledge of it, he can actually apply for the mismanagement, that it is not being properly managed. Next is when directors take no serious action to recover the amounts embezzled, because there may be some situation that there is a complaint of embezzlement, but the directors are not at all taking any action. Now, who will take the action? There is no FIR being done, or there is nothing being done. So in that case, the company's money is at the stake. So in that case, what will happen? These shareholders or these minorities can bring a action. Next is continuation in office of a, this I have already explained you, continuation in the office after expiry of the term of director, sale of assets at a low price without the compliance with the act. So the company's assets are at the disposal of the director, and if they are selling uh, the property of the company at a very less price, in that case also it will be said that there is a mismanagement. Next is violation of the memorandum. I already told you violation of memorandum is ultra vires act. Okay, violation of statutory provisions of the articles, and company doomed to trade unprofitability, or you can say company has been forced to go for a trading, and which is a unprofitable trading. If it is known, then it can they can file a suit for the mismanagement. So following are the acts which have been held to not amount to mismanagement acts. So there are certain acts which are which cannot be mismanagement. Okay, so what are these acts? So building up of reserves or non-declared of dividend, especially when it does not result in the valuation of the shares. So you are building up reserves, which are the, you can say, building up reserves for non-declaration. So dividend has not been declared, and the company is building up the reserves, or company is actually collecting the reserves, and dividend has not been declared. So in that case, what happens? You cannot, shareholders cannot file a suit against the company that the company has not declared the dividend, because there may be some agenda of the directors that why they are not declaring. So declaration of dividend itself is not, yeah, but once dividend is declared, and if it is any shareholder is deprived of payment of dividend, in that case there is a operation. Okay, so in that case the things can apply over here, but here if the company is merely not declaring dividend, it will not matter to mismanagement. Merely because company incurs loss, mismanagement can't be alleged. Okay, if the company is making loss from certain years continuously, it may be because of any of the reasons. And as the company is making loss, it cannot be said that there is a mismanagement in the company. Yeah, this can be improved, but on papers or there is no prima facie proof that what is the reason of this loss as such. Okay, next is arrangement with the creditors in the company's bona fide interest. So the company has done some arrangement with the creditors, or you can say the credit period has been extended. That can also not be a matter of mismanagement. Next is the removal of director or termination of director or work manager service. So if anyone is being terminated by the company because company is terminating some director or maybe some, so that person who has been terminated, maybe a shareholder cannot file a suit against the company for a mismanagement. So there are certain things which will not matter to be mismanagement, and there are certain things which matter as a mismanagement. So we have gone through both of the things. So now how to prevent the mismanagement of a company, or how to prevent this how there can be this prevention of mismanagement. So now what can be done? An application can be filed to the company law board. The first remedy is available to the oppressed minority is to move to the CLB. Okay, now it is called a tribunal. So NCLT you have to move on. So who can apply is given under section 399. So under section 398(1), any members of the company who complains that the affairs of the company is being conducted in a manner prejudicial to the public interest, or sorry, prejudicial to the interest of the company, or that the material change has happened. Okay, so a material change not being a change brought about by or in the interest of any creditors, including the debenture holders. So if any change has taken place in the management and control of the company, whether by alteration of the board of directors or by its managing agent or company secretary or anything else in the constitution and control of the company, or a body corporate acting as its managing agent. So whatsoever change it is. So whatsoever is the change, material change in the you can say in the management and control of the company, or in the ownership of the or the shares or any share capital, or you can say, okay, so if any such thing happens, so in that case and these things are prejudicial to the interest of the shareholders and the interest of the company, then the action can be brought in. Okay, now what is the relief against this mismanagement? So the court is of the opinion that if the court, now that there is the court must be convinced. So if the court is of the opinion that the affairs of the company are being conducted, aforesaid means the affairs are being conducted in a manner which are prejudicial. Okay, so or that by reason any material changes as aforesaid of the management and control has happened, or is likely to happen, or is likely to affect the affairs of the company in future also. So it may, so the court may, with a view of bringing the end or preventing the matters complained therein, may make such orders as is things fit. So what is the power of tribunal in such a situation? So what can the tribunal can do? Okay, so the tribunal can regulate the conduct of the company's affairs in the future. It can purchase the purchase of the shares and the interest of the members of the company, and other companies may also be controlled. In case of a purchase of the shares by a company as aforesaid, the consequent reduction in the share capital can be controlled. Okay, so the termination of setting aside, modification on any agreement which the company has entered into for any merger or acquisition, that can be also set aside. Okay, so that can be even result in or you can say the company can order for particular persons like managing director, the directors, managing agent. So there is some change in board regarding these, or there is some material change in the company's constitution or management and control. So it can be done. So upon next is the termination or setting aside of modification of any agreement which company has done, or setting aside of any transfer or delivery of the payment, or anything related to that, or any other matter which the court deem fit can be taken care of, or in this way there is a prevention of operation and mismanagement of the company as such. Okay, so what we have just now learned is that the affairs of the company must be in the favor of the company and its shareholders. Even there are, though the majority is having always its say, But there are certain instances where minority can also raise their head and challenge the company for its wrongdoing, and also it can be for their own favor if there is some infringement of any of the personal rights of the share, any of the individual shareholder of the company. Okay, so any problem in this, or if you are not able to understand anything, please tell me. I will explain it again to you. Yes, anyone? Any doubt? Anything? Fine then, 5 more minutes are remaining. So, any suggestion if you would like to give me or anything? So you are having your quizzes again scheduled. Okay. So I will take some quizzes of whatever I have taught before, and then afterwards also there will be certain quizzes which will happen regarding whatsoever we have studied till date in the last week itself. So Shreya, I think I should take quizzes in my class only. So I will just start doing it. Okay, so maybe on Monday you may have some quizzes. So there are 3 days for you to study. So on Monday, whatever we have studied before the directors, so we can have 2 quizzes on Monday itself. Is that okay? So one, yeah, on prospectus. So the topic will be the prospectus itself. Okay, I will just tell you the what topics I can take so that you need not to study the entire syllabus again. So the things which are on which we can just take the quiz is one is for sure the prospectus, because we didn't had any quiz on prospectus as such, and another is this membership of the companies also. So membership, prospectus, let me take it on directors also. So membership, prospectus and directors, please go through this part of the company law. You can even see my videos. I hope you have subscribed for the YouTube channel. So please see the videos over there, and I will see whether you have subscribed the channel or not. Okay, you must do it, everyone, because that is the way how you can actually revise. So I will also be able to understand and know that that those who are subscribed, I understand that they have some concern for themselves and they want to study properly. Okay, so please tell me how many of you have subscribed. Raise your hands virtually. Okay. Ankit, Astha, Ayush. That's it. Shara, Aditya, Tushar, Janvi Singh. Okay, Kaushal. So most of you have done it. So fine. The rest of you, please do it as soon as possible, because that will be one of the thing that you will be, fine. Put your hands down. Then let me take the attendance for the day, and you have 3 days for and thank you Shreya for arranging this extra class, because this was much needed for me. One more class is needed so that I may be able to fulfill the gap which I had before. So let me take the attendance now. Ayush Bothra, Janvi Singh, you have to say yes, sir. Ayush,
Yes, sir.
Janvi,
Yes, sir.
Asta
Yes,
Khandelwal,
sir.
Abhigyan,
Yes, sir.
Aditya, Ankit, anyways. So again, Ayush, Janvi, Yash, Yam, Tushar, Astha,
Yes, sir.
Gyan, Aditya, Ankit, Anshul,
Sir.
Arpit
Yes,
Mishra,
sir.
Yes, sir.
Ashwit, Ritik,
Yes,
Yes,
sir.
sir.
Preet, Jamima, Karan
Present, sir.
Agarwal, Kaushal, Meghna,
Present, sir.
Yes, sir.
Naman Jalan, Navya Singh,
Present, sir.
Neha Singh Rathore,
Yes, sir.
Raghav Dubey, Sambhav Garg, Sanya, Sarvan
Yes,
Sinha,
sir.
Yes, sir.
Gauriya Garg,
Yes, sir.
Yes,
Shahid
sir.
Khan,
Yes, sir. Yes.
Sara Khan, Shreya
Present,
Dhara,
sir.
Shivam
Yes,
Singh
sir.
Rana,
Present.
Vanshika,
Sir,
Vatsal.
you have not taken my name.
Yes, sir.
Present, sir.
Yeah, Ispreet. Actually, your
Yes,
name
sir.
was overlapped. I just put down your hands, all of you. Don't raise your hands while I'm taking attendance, because it overlaps some of the names which are there. So I'm not able to read sometime.
Sir, Pritam also.
Yeah, Pritam,
Sir, mine, sir. Ashutosh.
Ankit,
Sir, Naveen also.
Sir,
okay,
Ashutosh also, sir.
Naveen, Ashutosh.
Sir,
Present,
Priyanshi.
sir.
Okay, Priyanshi, yeah, your name was not visible at that time. Raghav Dubey,
Sir, Vatsal.
Present,
fine.
sir.
Vatsal,
Present, sir.
fine. Okay,
Raghav
dear.
Dubey.
Thank you once again.
Thank you, sir.
Thank
Thank
you,
you,
Welcome,
sir.
sir.
Yash.
Yeah.
Thank you.
Have
Thank
a
you,
nice
sir.
day,
Have a
sir.
nice weekend,
Have
sir.
a nice day. Bye bye. See you. Take
Bye,
care.
So,
Have a
sir.
good
sir,
weekend.
you have not
Take
taken
care,
my name.
sir.